Welcome to this episode of America's Future Law Matters. Each episode, we discuss important legal matters, America's judicial system, and amicus briefs filed by America's Future in high-profile cases nationwide, from the Supreme Court to the United States Circuit Courts of Appeal, to federal district and state courts, and not just high-profile cases, but cases we expect may have considerable impact on our daily lives, the lives of our families, our communities, and even our country. My name is Alicia Kutzer, and I'm here today with attorney Bill Olson. What's up, Bill?
Well, since I'll be quiet since we're discussing silencers. Go
No,
go ahead. You keep
I sure hope not.
at it.
We need you here, Bill.
Go ahead.
All right. For those of you who may not be familiar with this podcast, Bill and I talk about different cases, like I just mentioned, and just so everyone is aware, Bill has been a practicing constitutional and appellate attorney for decades. His understanding of our nation's foundational texts is unmatched. Bill, along with an outstanding team of attorneys, filed the amicus briefs on behalf of America's Future and their other clients with the goal of protecting and preserving America's rule of law. And that brings us to today's topic, today's case, today's amicus brief. So, Bill, today we're discussing a case that is in the petition stage at the Supreme Court of the United States. It is George Peterson versus USA. And we have America's Future filed two briefs so far in the case, one in March of 2025 with the Fifth Circuit Court of Appeals, and then now just this month, April 2026, with the Supreme Court. So this is a big Second Amendment case, and we'll get into sort of the details in a moment, but I know that, like you mentioned, we were talking about silencers. So I don't know if you want to talk about the facts of the case or if you want me to go over them. Either way. I always like hearing from you, and I'm sure everybody else does.
Well, I'll just say the biggest misnomer in the world of firearms is calling a suppressor that's attached to the barrel of a handgun or a rifle. The biggest misnomer is calling it a silencer, because anybody who's used a silencer realizes how bloody loud they are. It does take some of the shock away of firing any weapon, but it sure doesn't make it silent. And only in the movies where they goes ping ping. But that's it might be worth mentioning where this law came from. Do you want to cover that, or in 30?
The Firearms Act?
Yeah.
So in 1934, the National Firearms Act came to be, and with that, I'll pitch it back to you, Bill.
Well, this is at a time of prohibition, a time of Chicago gangland violence, and Congress, whenever there's a problem in the country that it creates, such as it did through prohibition, it has to create another problem to solve the problem it created. So it came up with the National Firearms Act to restrict the possession of certain weapons, mostly machine guns and the Tommy guns that you see in the movies with Elliot Ness and Capone, and also these firearm suppressors. We've almost given up arguing about it, but the government, when they want to regulate them, they always call them silencers. And at some point, I think the courts know that that's just a term that is not accurate, but it helps them win cases. And so in 1934, they came up with this concept that if they pretended to be exercising the Commerce Clause, they would have banned private ownership of machine guns or silencers or short barrel rifles or short barrel shotguns. They would have banned it, but they knew they couldn't do that. They didn't have that power under the Commerce Clause. So they went ahead and taxed it, because the taxing power is generally considered to be almost unlimited, as long as your purpose is really to impose a tax. So they came up with this $200 tax stamp, and where they actually have a stamp they put on your application when it's approved. And at the end of you have to apply for it. You have to submit fingerprints. You have to go through their background check and such, and at the end of that time, however long that may be, and it used to be very long indeed, they would give you the permission to acquire the silencer, and if you didn't acquire it, I'm sorry, if you didn't have the permission, it's a felony to be in possession of one, even to make one. So the silencer had to be um, approved, even if you were making it for yourself. It's a crazy thing, and fortunately, and this complicates the matter, but in the one big beautiful bill that President Trump came forward with, they decided to eliminate the $200 tax. And since it went through on a budget issue, they technically, I guess, couldn't change the underlying registration requirements, so that stays in effect. So now you have to apply for and be granted permission to buy something, but you don't have to pay the tax. And the curious part is, how do they justify the entire scheme? Because it's a tax. The tax is zero. So Gun Owners of America and some other many others organizations and many states are litigating that now in the Northern District of Texas. And there's another case pending in Missouri, I think, and perhaps others. And they're all designed to say, hey, if you're going to use the taxing power to justify it and there's no tax, then there's no tax, there's no justification, and the whole scheme of registration ought to fall. And I think that will be successful. Uh, but for poor
Is that
Mr. Peterson, he came along too early.
yeah, well, he was, like, right at that time, right? Like, I mean, this case has the travel of this case has been I don't think I've ever seen anything like it. But, so the big beautiful bill takes away the $200 tax, that's required, but the registration is left in place, even though the registration is sort of ancillary to the tax, right? Does this go is this the process for, gun licenses or just registering guns, or is this just for firearms, or is this just for, like, certain
Well, yeah, the National
items?
Firearms Act is silencers, machine guns, fully
Okay.
automatic weapons, and short-barreled rifles and short-barreled shotguns and destructive devices, which have to do mostly with bombs and grenades and things, and then any other weapon, which is a description of pen guns and things that are odd and curious, perhaps guns and canes and things. They made those illegal, and yeah, well, they didn't make them illegal. They mean you had to register them, and so it's not a
Federal,
ban.
right?
It's not a ban. It recognizes all these things are in fact firearms. It lets you buy them. It just tries to make it really, really difficult so that Al Capone's people could not have too many machine guns, I guess, destructive devices and the rest of it. We're just dealing with silencers. And the funny thing is, everybody concedes, even the court, even the Fifth Circuit, there's almost no use of a silencer in a crime. It just doesn't happen. You don't
Right.
see bank robbers putting silencers on. I mean, in movies, you can see this, but it just doesn't happen in the real world. And the funny thing is they also admit there are lots of benefits. So people who have hearing problems and they're gonna have additional shock from hearing, the round go off, or home defense where, it might be disorienting. You might have, muzzle rise without the silencer. You might have any number of issues. So it addresses noise pollution. It addresses the hearing of the person who's not necessarily have time to put on uh, hearing
Both.
protectors. So there's nothing but benefits and no downside. But the people that are friends in the Congress can't figure out why they can't just give it up, get rid of it, and let silencers go by. We've almost accomplished that a few times, but now I think we're going to have the courts impose it rather than Congress.
And it's a benefit, hunting, right? I mean, I would think
Yeah, yeah,
hunting
you
for your
scare off
food or whatever.
everything for miles around if you have one missed shot. So
Yeah. So that makes sense. Okay, well, yeah, so back to Mr. Peterson. In or right at the same time that Bruen came out, I think it was actually the same month, June 2022. Peterson, George Peterson, who was running, who owned, I guess, or had an ownership interest in a firearms store, so to speak, partially operated out of his home. There was an investigation into his mismanagement of this firearms store, and through that investigation, there were law enforcement officials that um, executed a search warrant on his home. In that, during that search, they seized a silencer, or a suppressor, or let's say silencer suppressor. The silencer suppressor was in the bedroom or basement closet, one of them, bedroom closet, let's say. They seized it. They then discovered, the law enforcement agency officials discovered that the suppressor was unregistered and the $200 tax at the time that was due had not been paid. So based on these violations, really disclosure rules violations, and you're right, Bill, I'm 100% in agreement with you. This is ridiculous. But anyway, based on those failure to disclose, failure to register, failure to pay tax, there were charges. There was an indictment against Mr. Peterson of, with respect to a felony. That's a felony charge. Those are really serious. So he gets the felony charge. He motions the court to dismiss based on, I think, two grounds. One was Second Amendment, that the registration and tax scheme under the NFA violates his Second Amendment rights. And I believe the other motion to dismiss was under the Fourth Amendment, invalid search and seizure or unreasonable search and seizure. So, so here we go. Now at this point, we're into October, I think, 2022, when he had filed the motion to dismiss. Bruen's out, so he's relying on Bruen, and as he should. And Bruen's that landmark case that the United States SCOTUS, or the Supreme Court of the United States, issued June 23rd, I believe, or 22nd of 2022, that just changed it altered the framework for addressing Second Amendment challenges. So anyway, um, so he files a motion to dismiss. In August 2023, the district court denies the motion to dismiss, and they deny it based on essentially that the suppressor is an accessory. Therefore, outside, it's not a bearable arms, which the court says means it falls outside the Second Amendment. Have I got that so far?
Yeah, which is crazy because it's the narrowest possible
Uh-huh.
view of a firearm. That's something that has to be essential for the firearm to operate. They say it to be covered under the Second Amendment. And while you mentioned that, I pulled the quotations from as to what a firearm was from Heller and Bruen, and it might be worth making abundantly clear how silly the Fifth Circuit analysis was. In Heller, the court instructed that arms, or, as used in the Second Amendment, means weapons of offense or armor of defense, and anything that a man wears for his defense or takes in his hands or uses in wrath to cast or strike another, and includes all firearms, um, quote unquote, all firearms. And then in Bruen, they went further and they said that that the arms includes anything that facilitates armed self-defense. Well, a silencer, the Fifth Circuit basically conceded, facilitates armed self-defense. So if you meet the test of Heller and Bruen, one would think you would win, but they still, in the first round, came up and said it's not an arm. It's not a protected arm.
Yeah. Do you think that that was just a way of sort of um, shouting from the rooftops to all the other lower courts, hey, this is how we can sidestep Bruen. We can get away with not addressing Bruen by just, unless it's a gun or a firearm that you actually have to pull a trigger to use, we'll just simply avoid Bruen, because Bruen is a tough standard for courts to sort of overlook until we get to the footnote 9. But do you think that's the reason that they were sort of like shouting from the rooftops, "Hey, we have an idea how to sidestep Bruen. Just don't make sure that everything that anytime a regulation challenges, anytime there's a regulation challenge under the Second Amendment, try to figure out a way to say it's not a gun or it's not a bearable arm."
Yeah, because Bruin's very clear. It says if it's a bearable arm, then the government has the burden to show that there is this textual prohibition on its on its private ownership or carrying, or that there's a relevant historical analog of registration going back to the founding era. It gets a little more complicated than that, but that's basically it. Either the text covers it, it's an arm, and then they have the burden shifts to the government. But the easiest way to avoid this, especially when there are no common law and founding era analogs, is to just say it's not an arm. No,
It's
no,
not covered.
no, not covered. We don't even
We'll
have
just
to
do it.
go any further. Don't have to think about it
No,
anymore.
nope. Regulations is it stays. So yeah, so when the district court they deny the dismissal. I'm sorry, district court denies the motion to dismiss. Next, as you mentioned, the Fifth Circuit affirms the denial of the motion to dismiss on the same grounds. They say too, "Hey, you're right, district court. So skippy. This isn't a bearable arm, so it falls outside the scope of the Second Amendment. No Second Amendment problems here." Okay. The next thing that happens, or one of how this case, this is where the case gets really sort of convoluted, but eventually there's a change in administration, I guess. I mean, there's probably some other stuff that I think there's a rehearing en banc petition filed by Mr. Peterson, that may have been when America's Future through you, Bill, and your team filed an amicus brief. But eventually, there is a change in administration from see you later Biden to President Trump 47, and the government changes position. And when the government changes position and puts out a policy saying suppressors, wait, what did they say? Ban on suppressors is unconstitutional, essentially
Well,
under
they
the
they
Second Amendment.
admitted that they were firearms, that
Yes.
firearms accessories are firearms, originally taking another position, but then the whole world said, "What are you, crazy?" And
Yeah, yeah.
eventually they had to shift their grounds, and once the litigant, the government defending the law, has shifts their position, the court has to look at it again. So would the Fifth Circuit say something like, "We assume it's an arm without deciding it's an arm, so now we're gonna go look at it in slightly more depth"? I think
Yes.
that's what
But I think, and then I think there was a couple of there was a new opinion issued by the district court that essentially, I think it was the district court, I could be wrong, that essentially said we are they basically retracted their denial of the dismissal and denied the motion to dismiss as moot. And then there was another couple of paper judicial whatever nuances that occurred, and eventually they came to the conclusion that you just laid out. And the government. So what happened there? Oh, interestingly, Trump's 47th administration, they took the position that the suppressors are covered under Second Amendment rights. Okay. Yet they didn't drop the case. They maintained that. Now, remember, Mr. Peterson is charged with a felony. So the Trump administration agrees that suppressors are covered under Second Amendment rights. However, they maintained the case. They continued the case going forward because from what I understand, the tax and the registration scheme was only a modest burden to the Second Amendment.
Yeah, this is really, crazy. What they did is they said, "Okay, now if we have to look at Bruen and we have to consider it to be a firearm, that under Bruen the question becomes, is this the kind of licensing scheme that was struck down in Bruen? In Bruen, it was a New York licensing scheme for public that restricted public carry. And New York said, we're going to have discretion as to who's allowed to carry in public. And the Supreme Court said, no, 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 you don't have discretion as to who's going to be allowed to carry in public as long as they qualify according to some objective standards. And then they added a footnote. And whenever the Supreme Court adds a footnote, some lawyer's going to argue this later. They said basically, we're not addressing the 40 states or whatever it is that have shall issue permitting that allow for carrying. So if it's shall issue without discretion, we're not talking about those cases.
Oh,
And
okay.
so here, this is not about carrying. This is about owning.
Right.
And the Fifth Circuit says it's the same thing. So we'll apply the principles of Bruen, which regulate who can carry, and we'll apply it to this, which is who can own. And they conclude that this is like a shall issue statute, and therefore it's protected and it's presumptively constitutional, and the government has no burden to prove it's unconstitutional. The reason it seems like it makes no sense is this makes no sense, because what it does is take this footnote, which says, here's what we're not deciding in the case. And it bases the decision on what they said they're not deciding. And the other funny thing about this case is that this is anything but shall issue. Um, it does it's you don't the individual doesn't have to prove that it's a hugely expensive price. They don't have to prove there are enormous delays. All they have to prove is that it's a firearm, and then the burden shifts. And that's what Bruen says. It's presumptively unconstitutional if it's a bearable arm. And they come in and say, well, under Bruen footnote 9, where you were saying what you weren't deciding, we're going to say this is a shall issue kind of situation, and therefore it's presumptively constitutional. You can't find support for this. And yet, the United States of America, the Department of Justice, are pushing this case. The Solicitor General, everybody thinks this is fine to restrict the Second Amendment in this way. And it just shows no matter how you change the government, that you can't change the mindset of the whole Department of Justice. And whereas if you asked, I don't know what position the president takes on this, but I certainly know that his Department of Justice is not taking a pro Second Amendment position so far in the litigation. We'll see.
So I want to go back because I've been meaning to ask you this question anyway. The shall issue versus may issue. I know I haven't done enough research on these and the differences on the distinction. So the shall issue, these are two different essentially ways of promulgating regulations. Some states in this area create legislation or create law that is shall issue. And I know you just said it. That means that if it's a shell issue, the state has essentially self, they're self-barring themselves. Am I right?
No
From
discretion.
no discretion.
You fill out the form, give them your name, your address, you say
Okay.
you're over 21 or whatever, you say that you haven't committed any felonies, you're not mentally ill, you're not a routine drug user, and
Um,
and then they look
a
at
shell
it, they
issue.
say, "You got it, shall issue." What New York did was the may issue kind of approach, which said, "Well, tell us about yourself, and let us see your social media, and we'll tell you whether we think you're a trustworthy person."
Yeah. Wow. That's so scary.
And the Supreme Court said, "Nope, they can't do
Yeah,
that."
that's good. Yeah, I guess we'll see about what the Trump. I mean, he did issue. I, as far as the president's concerned, since he came into office, it seems as though he's been issuing policies that are very much pro Second Amendment. But like you said, I mean, these agencies, these departments within the federal government, it's just so difficult. There's just too they're too large, they're too powerful, and they're too set in their ways, I guess, you know?
Well, there's so many exceptions to that rule. I mean, the you have uh, the Department of Justice still pushing this engage in the business rule that if you sell a gun or two, that all of a sudden it's not just you selling a gun, you're in the business and you have to register and get a license. And it wasn't until a day or two ago that they dropped an appeal of a case that they had lost. They're continuing to argue about frames or receivers, which is another different issue. So there are all these matters, and there is no coherent, consistent pro Second Amendment position coming out of the Justice Department. It may be coming out of the speeches of the campaign when President Trump ran, and even some since. And they are suing a couple of jurisdictions that have extremely bad gun laws, but there's many exceptions to their consistency on this issue.
Yeah. Well, hopefully they maybe the DOJ and President Trump will see this and get their act together when it comes to the Second Amendment,
Sure, that's the way it happens.
right?
We live in hope.
Mhm. Yeah. So for Mr. Peterson right now, he has petitioned to the Supreme Court to take the case up. And I mean, yeah, even if this scheme stays in place, I mean, for a felony indictment because there's an they've I mean, I got pulled over not too long ago. My car registration had lapsed. It can happen. I'm glad I wasn't charged with a felony.
Yeah, to think that somebody can create something in their garage to try to make your gun make a little less noise, and all of a sudden you go to jail for a year, is a crazy concept. It should not be this way. The Congress should not have allowed this to continue. They did what they could, sort of, I guess, through the one big beautiful bill. And now to think that the ATF and DOJ are still pursuing people like Mr. Peterson. So we'll see if they oppose granting of certiorari, but they've been pushing it up until now. And until people tell them that they're not satisfied with their Second Amendment record, they probably will keep pushing and prosecuting people like Mr. Peterson.
It's really sad and scary. Well, thanks, Bill. Thanks for all your insight. I guess we'll wait and see what happens to Mr. Peterson. I know that the case has been distributed for conference by to the justices, and so we'll wait and see whether or not they take up the case. If they do, hopefully, they issue some guidance to the lower courts as to Bruen and as to particularly footnote 9, and hopefully that indictment gets dismissed. It just doesn't pass the smell test to me. But anyway. So
Yep.
that does it for today, guys. I want to thank everyone for our listeners, our viewers, for joining us. It is so important to stay informed, particularly about issues that matter to you, your family, your community, and all of our fellow Americans. I also want to thank Bill and congratulate Bill and the team of attorneys that worked so hard to get all these amicus briefs filed. So so congratulations, Bill. Thank you. And I know that the hard work that you guys put in is saving our constitutional republic. If anyone would like more information about this case or to read the brief, please visit America's Future Law and Policy page at americasfuture.net. That does it for today, and we will see you soon for another episode of America's Future Law Matters.